So I'm Nancy Murray, Senior Staff Counsel with the Department of Fish and Game, and I am the Department Attorney representing the Department in the lawsuits that involve the hatchery EIR. As Scott mentioned, this is a simple request. Eliminate an exemption that had no biological basis to begin with. Totally separate from the lawsuit. It was made from the Fisheries Management Committee while we were actually drafting the EIR. We said, let's not get ahead of ourselves. Let's wait until after the EIR to actually go to the Fish and Game Commission with that very simple eliminate an exemption request. The CARF organization has filed a lawsuit as to the EIR, which will not affect whether or not you decide to eliminate an exemption for 37 counties that has no biological basis. So whether or not there is no benefit that I perceive, other than to possibly their case, to put off and delay. As Sankey mentioned, they've been coming to the Directorate regularly, not once this week, but twice. So they're getting access to the Department and our Director on a regular basis. And we need now to move this to the public. We really need a broader base. But short answer to your question, the lawsuit is going forward. We are working now. Right now, the hearing is set for March 25th. So the Attorney General is saying it is not realistic to actually go to court and argue the merits on March 25th, 2011, because we haven't started briefing. We need to talk about a briefing schedule, and we are not asking them to delay the actual, or there's been no talk or even thought that we would want to delay this elimination of an exemption for 37 counties,
okay.
Which,
That's
as
good.
to parity...
That's good.
Thank you. Okay, Commissioner Rogers.
Thank you. What would help me evaluate this, in addition to all of the things that have already been discussed, is sort of a bifurcation of the analysis, the economic impact analysis. I see two distinctly different categories here. One, I see commercial operators of fishing for a fee type ponds. And the gentleman, Douglas Elliott, was very erudite in his discussion, if not a little excited in his discussion with respect to the potential costs. Also involved in this is probably literally thousands of farm ponds, literally thousands, all throughout the state of California, that probably would have no direct access to waterways in the state of California, and were created, one, as irrigation devices, or perhaps not. Perhaps only as fun for the farm families or the people who work there or whatever. And they've been stocked on a regular basis by this industry. I would like to see someone, and whether it's the department is perhaps not that familiar with what EIRs on the outside and consultants on the outside cost, but some of the people who spoke today should be, in fact, familiar with that. What I would like to see, and I think would aid us as a commission in terms of assessing economic impact, would be to give an example of, say, a 5-acre pond on some person's farm, a privately operated 5-acre pond that is only for the enjoyment of the family or the employees or their friends. There's no commercialization. What would be if you will, not only the department's costs, which are readily accessible, given your distances and time and complexity, but also what would be the potential, and I would call it a parade of horribles. If this were to happen in accordance with the law that we are proposing, this sort of consultant would be necessary, or this sort of biological assessment would be necessary, or this sort of EIR would be necessary. And what are the potential costs of that? To me, to make the assertion that this has no economic damage, to no negative economic impact to the state of California, is something that I can thoroughly understand from the department's perspective with respect to your offsets and parodies and all that. But in terms of the actual person who owns and operates that pond, couldn't be more inaccurate. We all know that there will be substantial cost, if not horrific cost, involved in this. So I would be very interested, for those who spoke here today, maybe they can get together and come up with some examples. This is what could potentially happen if the following events were to occur. These critters were found, these were not, blah, blah, blah. I'd be very interested to see this, because this could be opening up a virtual Pandora's box for fishing opportunities on California's farms and ranches.
Salky, before you answer that, I want to clear something up in my own mind about what Richard was talking about. And I was under the impression that if a person owns a spread of property and they have a pond on it that they've been stocking with fish, so long as it's not fed by a state tributary or drains into a state tributary, they would be exempt from this? Because if they're not, I'll fill this room up myself with a bunch of friends.
Yeah, I'd like to clarify a few things. There is a fair amount of confusion, and Nancy, correct me if I'm wrong, but we're talking about stocking fish in the water bodies of the state. The definition of that is essentially it has to be connected to a water body of the state. It does not affect a pool or a scrape out on a hill that's not connected. The other confusion I'm also hearing, we are not changing the rules on in what circumstances you need a fishing license. That's set in statute. You can't change it. We can't change it. We're not changing that, just to be clear.
If I may, Mr. President, we need perhaps a better, as part of my concern, perhaps a better understanding of what connected to the state's waters means. Mm-hmm. In other words, for example, if you have a stock pond or something, in particular, I'm intimately myself familiar with irrigation ponds. Every single irrigation pond, if it's properly constructed, has a spillway, so that if some irrigator doesn't turn off the well, or it doesn't turn off the pump from the water district or whatever, that water goes over a concrete spillway, and then it eventually goes through their ditches and ends up in a state waterway. Maybe I'm wrong, but I think the vast majority of irrigation ponds, well, virtually every single one that I've ever seen, has that attribute. So does that mean that they are all, therefore, connected to state waters if the irrigator makes a mistake or comes the deluge again, and we get 12 inches of rain, and all of a sudden, where does that water go? If that's true, then all of those ponds are now not exempt.
I will let our lawyer respond to what would seem a simple question.
Right. And what we are trying here is simply to devise a regulation that implements Fish and Game Code 6400. They are trying to confuse it with sport fishing license. That is not what we're doing with this regulation. All we're doing is trying to implement 6400. 6400 says it is unlawful to place, plant, or cause to be placed or planted in any of the waters of this state any live fish, any fresh or saltwater animal, aquatic plant, whether taken within or without the state, without first submitting an inspection and securing the written permission of the department. Written permission of the department to put a fish in waters of the state. Waters of the state is defined in the Water Code, and there is a body of case law that does define that. It is a very broad definition.
So help me, is what I said specifically, the spillway of an existing irrigation pond, does that, and ultimately that water has to go into the farm ditches and then ultimately would probably end up in the waters of the state. Does that mean that irrigation pond is now a water of the state?
More likely, yes.
Therefore, I submit to my fellow commissioners,
they would need to submit
it is probably the case that every single irrigation pond in the state of California would not be exempt.
Yet
And
in
I need
many
information
counties today,
would you please? I need information to disabuse me of that fallacious understanding, and I need it from the lawyers, please.
and in terms of today, there are in Northern California, the counties that are not exempt, they are, in fact, getting private stocking permits, going through a PSEP. They are going through this.
Jim.
You're talking about
Commissioner
private
Richard?
irrigation ponds?
Yeah.
Wow.
Commissioner Richard.
Given we got way too many questions here in my mind to do anything right now. Initially, I was thinking that the delay to the resolution of the lawsuit might be appropriate, but I don't think that's appropriate now that I've... You can sit down now. We're not gonna shoot. But I think you gave a good answer there, and I think we got all that. So I'm not so sure that's correct. But the 120 days does seem appropriate to me, given what Sankey had said and the request of the parties that are involved. So I'm thinking we should have no action today. I'm thinking we should give them 120 days and better figure out how to do it, because in 120 days we ought to get this done. And lastly, I want to throw in there a bit of a monkey wrench, because I'm sure the people affected by this would be happy with what I just said, but they may not be happy following this, because I think we have a difference here of commercial and non-commercial matters.
Yeah, no question.
And so on a non-commercial matter, where nobody's paying to fish there, if I go to Richard's pond and he invites me over and we do a little fishing and the kids are fishing and everything, I'm not seeing a license is necessary for that. But for a commercial venture, I'm actually thinking it may be appropriate. And I think we need to get some data on what we're talking about here. I don't know how many people that is, but my brain says when we teach particularly young people, but anybody, that it's okay to fish in the state without a license, I don't think that's necessarily the best thing we can be doing. I'm open to discussion on this, but I got to tell you, it seems to me we ought to be having licenses for everybody that's fishing in the state, excepting when it's on your private property and it's a non-commercial event, because I see them as different deals.
Yeah.
So
I mean, I'm not sure I agree with that myself, because, we've taken away fishing opportunity from a whole bunch of California citizens already. And I think mostly that you got young people who are just starting out fishing in these commercial places that.
Well, we do and we don't. Is this or is Irvine Lake? Is it stocked? Because I know a lot of my golfing buddies go down there, and they're nowhere near kids, and they, I don't know if they have a license really. I've never asked them, but I would think that they should have a license.
Yeah. There's definitely a whole bunch of unknown that we need to know before we do that. Salky?
What I'm hearing is you'd like a little background on this issue of where a license is required. We will double check, but I do not believe the Commission has authority to designate where you get to use a fishing license. That's set in statute. But we'll bring back that information so you understand that a little more clearly. And the less discussion about the crimes you might be committing currently, the better.
Do we need a motion or something?
If I may reiterate,
I think we can just give direction.
If I may just make one comment, Mr. President. Once again, I asked the people who presented today to provide the Commission with more information with respect to potential economic damage. Bifurcating this issue between as Dan and everyone points out, fishing for hire, if you will, fishing operations that make money, and then someone's private irrigation pond where nobody but friends or family or employees uses it. And then I really want to understand this issue of the spillway on a private irrigation pond in the middle of, you call the county, I don't care what it is. Someone could come up to you and say that was now that at some point in time might connect itself to the state waters, and I need to have a definitive answer on that. I need to understand that. Thank you.
Okay, so just so I'm clear, contingent on your motion,
It's not a motion. It's just going to be a commission direction to delay this implementation for 120 days and give them opportunity.
Sure, 120 days. But so